Article 342 of the Constitution of India, Scheduled Tribes, Explanation. Article 342 of the Indian Constitution is an essential provision under Part 16, titled Special Provisions Relating to Certain Classes. It specifically deals with the identification and notification of scheduled tribes, STs, who are historically disadvantaged indigenous communities requiring special protection and support. Constitutional recognition of scheduled tribes. Clause 1 of Article 342 empowers the President of India to specify, through a public notification, the tribes, tribal communities, or parts or groups thereof that shall be recognized as scheduled tribes for purposes of the Constitution. This can be done with respect to any state or union territory, and in the case of states, after consultation with the governor of that state. The consultation ensures that the inclusion of any tribe is informed by the socio-cultural realities at the local level. The identification of scheduled tribes is not uniform across the country. What is recognized as a scheduled tribe in one state might not be so in another. This localized approach reflects the diversity of tribal populations and their unique relationships with land, culture, and tradition. Power of Parliament to amend the list. Clause 2 vests the power exclusively in the Parliament to make additions or deletions to the list of scheduled tribes specified in the President's notification. Through legislation, Parliament can include or exclude any tribe or tribal group from the list. This provision ensures that changes occur through a democratic process involving debate and discussion, thereby preventing arbitrary alterations. Importantly, this clause stipulates that once the President has issued a notification under Clause 1, that notification cannot be altered except by an Act of Parliament. This safeguard prevents executive overreach and maintains procedural transparency and constitutional balance. Significance of Article 342. Article 342 plays a critical role in the administration of affirmative action policies, such as reservations in education, employment, and political representation for scheduled tribes. The recognition of a community as a scheduled tribe enables access to protective and developmental schemes specifically designed to uplift their socio-economic status. This constitutional provision also acknowledges historical injustices and seeks to promote equality of opportunity as envisioned in the preamble and Articles 14, 15, and 46. Conclusion. Article 342 serves as a cornerstone for India's tribal protective framework. It recognizes the unique needs and identities of tribal populations and provides a structured, constitutional mechanism for their identification and inclusion. By assigning this responsibility to both the President, with state-level consultation, and Parliament, the article ensures that such recognition is grounded in both administrative expertise and legislative oversight. This balanced approach preserves the rights of scheduled tribes and supports their development within the framework of Indian democracy. The Constitution of India. Part 16. Special Provisions Relating to Certain Classes. Article 342. Scheduled Tribes. 1. The President may, with respect to any state or union territory, and where it is a state after consultation with the governor thereof, by public notification, specify the tribes or tribal communities or parts of or groups within tribes or tribal communities which shall for the purposes of this Constitution be deemed to be scheduled tribes in relation to that state or union territory, as the case may be. 2. Parliament may by law include in or exclude from the list of scheduled tribes specified in a notification issued under Clause 1, any tribe or tribal community or part of or group within any tribe or tribal community, but save as aforesaid a notification issued under the said clause shall not be varied by any subsequent notification.